Hello, I'm Robert Parker and I'd like to welcome you to today's webinar from the ICO, which is entitled Data Protection Now and in the Future, an introduction for small organisations in the healthcare sector. You'll be hearing from Lauren Irith and Liz Mackay, who are from the ICO's Assurance Department. They'll be taking you through the slides and, including questions, we expect the session to run for around 40 minutes. The slides and the notes from this webinar will be available on our website from tomorrow. Now, if you're not able to stay with us throughout, a recording of today's webinar will be available on the ICO's website by close of play tomorrow as well. Now, regarding questions, please would you submit your questions as they occur to you throughout the presentation, and I'll put the most frequently asked to Lauren and Liz. So I'd like to now hand over to Lauren.
Thank you, Robert, and welcome to our webinar today. So the webinar is going to cover the following key objectives. We're going to help you understand the work that's done at the ICO, give you a basic understanding of the principles of data protection, give you a basic introduction to the General Data Protection Regulations, or GDPR, and we're going to highlight some of the key risks to privacy compliance for health sector organisations. Firstly, just a bit about us at the ICO. Hopefully you'll be aware of us already and that we are the regulators of the Data Protection Act and the upcoming General Data Protection Regulation, or GDPR, from May 2018, amongst other things. But just to give you some background information, we have approximately 400 staff overall, including some small regional offices. Our main office is based in Wilmslow in Cheshire, and as I mentioned, Liz and I are from the Assurance Department. We carry out audits of larger organisations such as NHS trusts, police forces and local councils. And we also conduct one-day advisory visits to charities and smaller organisations, as well as carrying out information risk reviews, which are a more detailed review of data protection processes. As well as all this, we occasionally conduct one-day workshops to try to focus on data protection related issues in order to help raise awareness of compliance. The ICO's role is to encourage good practice, assess eligible complaints, advise individuals and organisations, and take appropriate action where legislation has not been complied with. Really, the role of the ICO is twofold. It's to educate data controllers on their obligations and protect the rights of individuals. As well as promoting good practice and providing advice, the ICO carries out enforcement work, which is more the punitive side of the ICO's role as a regulator. Reported breaches are investigated and appropriate enforcement action is taken. The specific actions that our enforcement team can take following investigation of an information security breach are to issue a civil monetary penalty notice, which could lead to a fine ranging up to £500,000, to issue an enforcement notice, which is a formal notice requiring an organisation or individual to take the action specified in the notice in order to bring about compliance with the Act and related laws. Failure to comply with a notice is a criminal offence. And finally, to request and agree an undertaking with the organisation. A formal undertaking can be given by an organisation to the ICO, committing the organisation to a particular course of action or otherwise achieving compliance. The requirements under the GDPR for breach reporting by data controllers and processes have been strengthened, and it introduces a duty on all organisations to report certain types of data breach to the ICO within a 72-hour timeframe. In addition, there will be a two-tier sanction regime introduced, and fines will be significantly enhanced for more serious breaches. Finally, the ICO also provides advice on a case-by-case basis via our helpline, as well as investigating written complaints from the public about organisations.
Before we go into the finer details of data protection law, I'd just like to pause and reflect on the possible impact of personal data breaches. The slide on display depicts a real ICO case example from 2013. An insecure Yahoo email account was used by the Burnett surgery for communicating with patients about smear test appointments and results. The email account was hacked. Put yourselves in this position. How would you feel if you were one of the patients affected? If it was your organisation whose email was hacked, how would this affect your practice? How would this affect your patients? This is just one example from many, demonstrating why data protection is important for everyone. The basis of data protection centres around personal data, but what is personal data? The Data Protection Act, or the DPA, defines personal data as data which relate to a living individual who can be identified from those data, or from those data and other information which is in the possession of, or likely to come into the possession of, the data controller. Like the DPA, the GDPR applies to personal data. However, the GDPR's definition is more detailed and makes it clear that information such as an online identifier, for example, an IP address, can be personal data. This definition provides for a wide range of personal identifiers to constitute personal data, reflecting changes in technology and the way organisations now collect information about people. In addition, personal data that has been pseudonymised can fall within the scope of the GDPR. Okay, what about sensitive personal data? What kind of data would be classed as sensitive personal data under data protection legislation? Under the DPA, sensitive personal data is data concerned with racial or ethnic origin, political opinions, religious beliefs or other beliefs of a similar nature, membership of a trade union, physical or mental health or condition, sexual life, the commission or alleged commission of any offence, or any court proceedings or sentence relating to any offence committed or alleged to have been committed. Interestingly, financial information is not defined in the Act as sensitive personal data. However, in this day and age, many people would class it as such. Under GDPR, sensitive personal data is known as special categories of data. These categories are broadly the same, but there are some minor changes. For example, the special categories specifically include genetic data and biometric data, where they are processed to uniquely identify an individual. Personal data relating to criminal convictions and offences are not included, but similar safeguards apply to its processing. So how does data protection relate to you? Protecting people's information rights and personal data is a frontline service. Taking a positive approach to your responsibilities will deliver benefits to your organisation, as well as helping you to comply with data protection legislation. Therefore, it's important to understand the benefits of getting it right and the implications of getting it wrong for your organisation. Benefits of doing it right include: it will help your organisation to comply with its legal obligations under information rights law. It will save your organisation time, effort and money. Information is a key business asset. Handling it properly will help your organisation to achieve its business objectives. Good data protection practice builds up good relations and trust with the people you deal with and the public as a whole. Impacts of doing it wrong could include financial and reputational costs. A data breach can be expensive to put right and will reduce public and customer confidence in your organisation. And you may receive a monetary penalty from the ICO. Data protection legislation also gives an individual rights concerning their personal data and the processing of such data. Although we won't be going into this aspect in any great detail today, it's important to understand that the legislation does include these rights for individuals as well as requirements for organisations. It's important to make sure everyone in your organisation understands the importance of information rights and their own responsibility for delivering them. Now, this might seem an obvious statement. However, for clarity, data protection legislation applies to a particular activity, processing personal data, rather than to particular people or organisations. So if you process personal data, then you must comply, and in particular, you must handle the personal data in accordance with the data protection principles. Broadly, if you collect or hold information about an identifiable living individual, or if you disclose, use, retain, or destroy that information, you are likely to be processing personal data. The scope of both the current Data Protection Act and the upcoming GDPR and Data Protection Bill are therefore very wide, as they apply to just about everything you might do with individuals' personal details. We are now going to move on to talk in more detail about the principles of data protection. The Data Protection Act of 1998 has 8 principles. Principle 1, personal information must be fairly and lawfully processed. Principle 2, personal information must be processed for limited purposes. Principle 3, personal information must be adequate, relevant, and not excessive. Principle 4, personal information must be accurate and up to date. Principle 5, personal information must not be kept for longer than is necessary. Principle 6, personal information must be processed in line with data subject rights. Principle 7, personal data must be secure. And Principle 8, personal information must not be transferred to other countries without adequate protection. This slide shows you the new GDPR principles. Personal data should be processed lawfully, fairly, and in a transparent manner. It should be collected for specific, explicit, and legitimate purposes. It should be adequate, relevant, and limited to what is necessary. It should be accurate and, when necessary, kept up to date. It should be kept in a form which permits identification of data subjects for no longer than is necessary for the purposes for which those data are processed, and processed in a manner that ensures appropriate security of the personal data. As you can see, there are obvious similarities with the existing DPA principles we've just talked about. However, there is a new requirement for all data controllers to be able to demonstrate their compliance with the new principles. This is centred around accountability. Basically, the GDPR requires you to show how you will comply with the principles, for example, by documenting the decisions you take about a processing activity.
So moving back to the principles under the Data Protection Act, we're going to go through them in a little more detail. Starting with Principle 1, personal information must be fairly and lawfully processed. Now we can break this principle down into 2 parts. Firstly, let's think about fair. Processing must be fair. You should have a legitimate reason for collecting and using the data. You should be transparent about how you will use the data, handle the data in a way that would be reasonably expected, and not use it in ways which would have an adverse effect on the individual. This can be achieved through the provision of fair processing information, also known as privacy notices, which identify the data controller, the purpose of processing, and any other relevant information. Personal information must also be lawfully processed, so processing must be done in line with requirements within the legislation, plus any other sectoral, legal, or regulatory requirements, any contractual requirements, and any duty of confidentiality. So the often neglected second principle. This principle is closely linked to the first principle, in that it also aims to ensure that organisations are open about their reasons for obtaining personal data, and that what they do with the information is in line with the reasonable expectations of the individuals concerned. If an organisation intends to use the data they hold for purposes other than what it was collected for, they should inform the individuals concerned. To give an example, if a GP disclosed his patient list to his wife, who runs a travel agency, so that she can offer special holiday deals to patients needing recuperation, disclosing the information for this purpose would be incompatible with the purposes for which it was obtained. We're now going to look at the next few principles in a little more depth. Together, known as the Information Standards or Data Standards Principles, they seek to regulate the amount of data collected about a person by an organisation, the quality of that data, and how long it is kept for. Our view is that organisations should be striving to do this in any event, as if you're guided by these principles, you can increase efficiency and reduce costs. The next principle states personal information must be adequate, relevant, and not excessive in relation to the purpose or purposes for which they are processed. Under GDPR, this is very similar in that personal data should be adequate, relevant, and limited to what is necessary. Think of this as the Goldilocks principle. The data collected should be just right. Too much risks an invasion of privacy. Too little risks ill-informed or poor decisions made which can affect that individual. This process is also referred to as data minimization. So if we break this principle down into its constituent parts, and we'll carry on with the three bears analogy. Firstly, personal information must be adequate. This is about having enough information to fulfill your business need. So to give an example, one of the purposes for which you might collect personal information is for treatment for a bad back. If an individual has now or has in the past had a manual labour-intensive job, then you'll need to know their career history. However, if you are treating this patient for an ingrown toenail, then you may not require a record of their full career history to carry out the treatment. Personal information must be relevant. This depends on the individual case, but examples of information collected could include a home telephone number, a star sign, political affiliation, religious beliefs. Well, how about if a family member's information is collected as a next of kin? Think about your justification for collecting information on a case-by-case basis. And information must not be excessive. This relates back to the point I made earlier about data minimization. So if your office or medical centre has visitor protocols in place that require the capture of personal data relating to those visitors, such as biometric fingerprints, consideration should be given to the type of data collected, how much data is held, and how long data is being retained for. So to recap on the third principle, the data collected should be just enough to fulfill the purpose for which you've collected it. You should be able to justify why you need to have all the separate pieces of personal data about each person. And information shouldn't be held just in case it might be useful at some point in the future. Now, there are clear business benefits to this principle. By minimizing the data you hold, you make it easier to locate relevant information and cut down on the need to store data, as well as reducing the burdens of responding to a subject's access request. Moving on to the fourth principle. This is possibly the most complicated of the ones we're going to look at, but it's so short it doesn't seem like it at first. In fact, this principle in both the Data Protection Act and the GDPR is the same. Personal data shall be accurate and, where necessary, kept up to date. So let's break this principle down. Personal data has to be accurate. So what do we mean by this? The term accuracy is not defined in the Act, but it does say that data would be deemed inaccurate if it is incorrect or misleading as to any matter of fact. And what does the Act mean by a matter of fact? This will be something you can demonstrate to be true, as opposed to someone's opinion or belief. So, for example, a date of birth or an address. To give an example here, if a patient moved house within their local area and the record at the health centre says they still live at the old address, then that record would be inaccurate as a matter of fact. However, if the record says they used to live at the old address, then it will be accurate. I would note here that there is an expectation on the individual to ensure that their personal information is kept up to date. So the duty for the organisation to take reasonable steps to verify the accuracy of the information will depend on the importance of the information and the impact that getting it wrong would have. For example, an HR department processing a job application for external candidates would need verification that any candidates had actually held the required essential job qualifications they listed on their application form. But they would have less need to check whether details about a summer job held 20 years ago are correct. Data must also be kept up to date. However, it may become inaccurate over time. For example, if a patient's next of kin moves address or changes their contact number. Organisations are expected to carry out periodic checks to ensure that data is up to date. Although clearly, as I said earlier, there is some expectation on individuals to inform organisations where personal data has changed. And information must only be kept up to date where necessary. So where it's necessary for that information to be up to date, for example, if the patient subsequently migrates abroad, it may then no longer be necessary to continue to update that information. There are some situations where it's okay to hold information which is no longer correct. An example here could be if a mistake was made, so if a member of staff was disciplined for an incident that later turned out they didn't commit. This would still be an accurate record of the events that took place and may need to be retained. However, the notes should make clear that the discipline was an error. And as an organisation, what should you do if accuracy is challenged? Firstly, you should investigate, and if you agree, correct the information or mark it on the record as a mistake. It's always good practice to ask for evidence if possible and carry out checks to verify at this stage. Under current legislation, there is no right for an individual to require you to delete information they believe is inaccurate, but they can apply to a court to do so. Then, if you disagree with the initial challenge, it's good practice to record the fact that it has been disputed. Now moving on to look at opinions under Principle 4. Opinions about individuals are personal data. However, generally, opinions cannot be challenged under the fourth principle. For example, if a patient doesn't agree with the comments of a health professional in their medical record concerning their condition or diagnosis, the patient is unlikely to be able to challenge the accuracy of the data under the fourth principle. The disputed data will be the view of the health professional who took the notes and is therefore an opinion about the patient's medical condition or diagnosis. Professionals' opinions are often an area of contention. Sometimes an individual may ask for an opinion or diagnosis to be deleted because they believe it to be inaccurate. However, if the record accurately reflects that professional's opinion, then it will remain accurate. An example of this may be if a patient's medical records from their doctor say they have depression, but they don't agree, so they write to their doctor to challenge this. However, this was the doctor's opinion at that particular time, and the records accurately reflect this. The doctor can simply put a note on the patient's record to say they don't agree. As we've already said, according to the legislation, the data is inaccurate only if incorrect or misleading as to any matter of fact.
Now going to look at the fifth principle. The fifth principle states that personal data processed for any purpose or purposes shall not be kept for any longer than is necessary for that purpose or those purposes. Now, the law doesn't provide any interpretation of Principle 5, nor does it set out any maximum or minimum retention periods. There are, however, certain considerations that organisations must take into account when setting retention periods. First of all, any judgment about retention of data should consider any statutory requirement to retain the information, any industry guidelines or standards, the value of that information, the risks of retaining the information, and the need to keep the information accurate and up to date. The potential risks of retaining the information too long could include, if it goes out of date, the wrong information could be used in error, The more time passes, the more difficult it may be to ensure the accuracy of the information, and it could mean more work in responding to a subject access request. Information that's kept for longer than necessary is also likely to be excessive or irrelevant and may be inaccurate as well, so there may be issues with Principles 3 and 4 too. However, you must take care not to delete the data too soon, as it may risk breaching Principle 3. Personal data must be adequate. The fifth principle is there to prevent you from retaining personal data without good reason. Any personal information that has become redundant should be deleted. But any deletion needs to be done securely. For example, you can't just put paper into a bin. It needs to be shredded. And this links into the principle on information security. Some organisations have automatic systems set up to delete types of electronic personal data after set periods. Information that's kept for historical, statistical or research purposes can be kept indefinitely. This is known under current legislation as the Section 33 exemption. It can be kept for these purposes as long as it isn't used in connection with decisions about an individual or in a way that is likely to cause damage or distress. However, if the information is no longer needed for the purposes, then the exemption won't apply and it should be deleted. The sixth principle relates specifically to the rights of individuals, namely the right to know who will see and use their personal data, the right to know why their data is being collected and what it will be used for, the right to have copies of all their personal data that is being processed or held, and the right to have any codes or jargons within provided copies of their personal data explained to them. The first two rights can be fulfilled by organisations through the implementation of controls, such as fair processing notices and privacy policies, and the second two relate to subject access requests, or SARs. Under GDPR, individual rights, including subject access, are not covered within the principles in GDPR. Instead, they are covered under separate articles.
The main rights for individuals under the GDPR will be subject access, to have inaccuracies corrected, to have information erased, to prevent direct marketing, to prevent automated decision-making and profiling, and data portability. On the whole, the rights individuals will enjoy under the GDPR are the same as those under the Data Protection Act, but with some significant enhancements. If you're geared up to give individuals their rights now, then the transition to the GDPR should be relatively easy. One of the key rights for individuals under both the Data Protection Act and the GDPR is the right to access their personal data that an organisation holds about them. This is called a subject access request, or a SAR. The requirements under the current law for data controllers are as follows. You have 40 calendar days to respond to a SAR, even if nothing is held. If you do not have clear, effective procedures in place, with responsibilities assigned, it will be challenging for you to meet the deadlines. You must provide copies of the information in permanent form. However, you do not necessarily need to provide the originals. And you must provide all copies held at the time of the request, regardless of whether they're scheduled for deletion. The subject access request process itself puts certain requirements on the requester too. Namely, requests must be in writing. However, the request itself doesn't have to specify or name the Data Protection Act specifically. Requesters should provide proof of identity so that the data controller can verify who is making the request. Requesters could be required to pay an administration fee. This is normally £10 and can be up to £50 for manual health records. And the data controller can ask for clarification of a request, more information, or the fee if this has not been provided initially. This stops the clock in terms of time for the data controller to respond. The rules for dealing with subject access requests will change under the GDPR. However, the main change is that in most cases, an organisation will not be able to charge for complying with a request. And under normal circumstances, an organisation will have just a month to comply rather than the current 40 days.
Moving on now to the 7th data protection principle. This principle focuses on information security. It states that personal information must be secure. Organisations should have appropriate technical and organisational measures in place to protect the personal data that they handle. So, why does information security matter? Getting information security wrong can have both financial and reputational implications to the success of any organisation. It can also cause damage or distress to an organisation's service users, patients or customers. As was seen in the recent WannaCry ransomware virus incident that hit many NHS organisations, it is extremely important to apply the correct resources, checks and balances in this area to avoid the reputational and financial risks that were realised in this recent attack. As the slide states, some examples of the harm that could be caused by the loss or abuse of personal data could include lost or misfiled patient test results, where follow-up medication had been prescribed but was never delivered, which could present a threat to life or well-being, patient records relating to sensitive issues being disclosed with possible serious implications, or the lack of availability of vital patient data in an emergency situation. Not all breaches are as serious as this, but many can still cause embarrassment and inconvenience, and people are entitled to protection from that as well. Advances in technology make the processing of personal data in bulk much easier, but also increase the potential harm that can arise from mistakes. For example, thousands of records can be stored on a single memory stick, which is small, portable, and therefore easy to lose. In the past, it wouldn't have been physically possible for an employee to carry that much personal data around with them. We would like to draw your attention to a particular case where the ICO issued a civil monetary penalty, with the risks of poor information security controls were highlighted. This breach occurred in March 2012, when the website of the British Pregnancy Advisory Service, or BPAS, was attacked. The attacker used an automated tool to identify website vulnerabilities. These tools are widely available on the internet and target well-known vulnerabilities and poor website coding practices. BPAS's website enabled users to request a callback for advice by completing a web form with contact details. Unknown to BPAS, the website retained a copy of the callback details unnecessarily, and this was available to the attacker after he gained access to the website's content management system. Fortunately, the attacker was not able to publish this information, which was recovered by police. BPAS have now removed the callback details from the website and taken substantial remedial action to ensure that this security breach will not be repeated. This incident was deemed to be a breach of the 7th principle. In particular, BPAS failed to take appropriate technical and organisational measures against the unauthorised processing of personal data stored on their website. In addition, the breach was of a kind likely to cause substantial damage or substantial distress. Users of the website could have been caused distress simply by knowing that their personal data had been accessed by the attacker and by the concern that the data may have been further disclosed. How would you feel if this was your data? How would you feel if you had been responsible for the breach? How would this affect your organisation? How would this affect your clients or service users? It's important to be aware that the data protection principles interconnect. This means that failure to comply with one of the principles can lead to problems with the others. For example, failing to keep information up to date when circumstances change may cause information that was originally adequate to become inadequate. Keeping information longer than necessary may mean that the information becomes irrelevant or excessive. All these can have an effect on the principle which relates to the security of data. Without maintaining the quality of data you process, you are not only likely to breach one of these principles, but in addition, your organisation will be run less efficiently. You'll be wasting money and causing reputational damage. Some key questions to ask yourself when you start any new process or are reviewing an old one are why the information was collected in the first place. Have you defined the purpose for which you are collecting it? What information do you need in order to fulfill that purpose? Are you collecting just the right amount? How long has it been or needs to be held for? So how will you ensure that the information is maintained and is up to date? You should regularly check the quality of the personal data you hold, correcting any inaccurate records, removing irrelevant ones, and updating out-of-date ones. It may not always be practical to check the quality of every record you hold, but it should at least be possible to check a sample.
Okay, well, thanks very much. Got a few questions, and thanks very much for everyone who's submitted one. And just in case anyone missed the beginning of the recording, it will be available on our website along with the slides and the speaker notes tomorrow. Anyway, back to the questions. There's a few that we can go through now. Another one, how does the right to be forgotten work with GDPR and healthcare information?
In relation to healthcare information, if it's required to be held under a statutory or legal requirement, it can't be deleted. So only under certain conditions can information be deleted. There is a lot more information about the right to be forgotten available on our website, and we are going to be covering GDPR in more detail on our workshops, and I can give you a little bit more information about those at the end of the session.
So there will be more information about the workshops, and one of the questions actually did ask for a recommendation, an ICO recommendation on a training provider. And unfortunately, as regulator, we can't offer a recommendation, but we are doing these sessions ourselves, and our website too will be regularly updated with more information. So I'm afraid that's the best I can do in terms of a direct steer for a training provider. But we know there are plenty, and many of them are excellent. A couple more questions. Does physical or mental health include all records of a medical nature?
That's a short answer, that's a yes.
Okay, good. And we've had the what size businesses must comply. Slightly longer question. I work in schools as a speech and language therapist. I'd like some guidance on how long I should retain case notes for students that I've discharged. Is it reasonable to discharge case notes after 2 years, or when they leave school, whichever happens sooner?
So we've touched on this point briefly earlier when we talked about the fifth principle. The Data Protection Act, it doesn't provide any interpretation, it doesn't set any maximum or minimum retention periods. We would say that it's a judgment in relation to retention, and that judgment should consider statutory requirements to retain that information, any industry guidelines or standards, the value of that information, and the need to keep it accurate and up to date.
Okay, that's enough questions for now. Hopefully there'll be a few more before we finish, but I'll hand back to Lauren and Liz.
Thank you. So moving on to talk a little bit more about the general data protection regulations. It might be reassuring for you to know that many of the definitions and the principles in the GDPR are broadly the same as those in the DPA. If you're currently subject to the DPA, it's highly likely you'll be subject to the GDPR. However, there are some notable changes, particularly in relation to an organisation's obligations as a data processor, as data processors now have certain data protection obligations under the GDPR. As discussed previously, the broad definition of what's classed as personal data remains the same. However, the definition under GDPR is more detailed, and sensitive personal data is referred to as special categories of personal data. It's broadly classified the same as the Data Protection Act, with the addition of genetic and biometric data that's processed to uniquely identify an individual. Now moving on to key risks for you as small to medium-sized enterprises in the health sector, in some of the main compliance areas within the legislation. These risks have been identified using the work that our assurance team has carried out over the past few years within the health sector, with various types and sizes of organisation. So thinking about the information security risks to an organisation, system access is one of the key risks that arises within the work of assurance. So thinking about if employees leave your organisation, they're not removed from a system, they could potentially still have access to personal data and disgruntled ex-employees are a common security threat. Thinking about clear desk policies, so if paper records are left out on a desk, that could lead to the risk of unauthorised individuals obtaining knowledge of a person's medical condition or other personal information. If service users are local to the area, you could be responsible for someone overseeing that information, which could lead directly to a serious complaint. Encryption is an absolute must. Without this, there's no excuse if a breach were to happen. A stolen laptop is relatively inexpensive, but people's sensitive data can be accessed on it. You may be facing a hefty fine. And if your service users come to your premises for treatment, you need to ensure that they're unable to obtain anyone else's information. So thinking about the physical security protocols that are in place in your premises. How would you know, for example, if a file was removed from your premises by a member of the public? It's essential to ensure that you have password security procedures in place. And another key risk we've identified is a lack of effective security incident monitoring or reporting. So think about how you or your staff would know how to identify and report a security incident. Sorry about that. So here's a very recent example of a data breach that highlights some of the key risks we've just discussed. This was a Bupa data breach which affected 500,000 insurance customers and was reported last month in July. Bupa disclosed a data breach whereby an employee inappropriately copied and removed information relating to 547,000 international health insurance plan customers. Customers with domestic health insurance were not impacted, but UK customers may have been affected if they purchased plans for use while abroad. Stolen data included names, dates of birth, nationalities, and some contact and administrative information, but not any financial or medical data. There are obvious questions to be asked in this case around the appropriateness of the access controls that were in place, the use of any removable media, and any proactive security monitoring that was taking place.
Manual records pose a particular risk, as it is very easy for paper files to be misplaced, lost, or removed. Without systems in place for logging and tracking manual records, these records could be lost while being moved from one area of an organisation to another. In some instances, organisations have not known when a record has gone missing, or even if they had it in the first place. Without secure storage areas for records, there is a risk of records being lost, damaged, inappropriately disclosed, or even stolen. We have seen premises where archived records were kept in an unlocked and damp cellar. Data in manual records should be kept accurate and up to date. If an address on a file is wrong, for instance if a client has moved and the address has not been updated, this could lead to medical information being sent to the wrong address and either being lost or read by the wrong person. Organisations must be aware of the risks involved if staff are not trained in records management. Even if permanent staff are trained, what about the risks involved with volunteers, work experience students or temporary staff? How soon is training arranged for new starters? It only takes one person to make a mistake, but there can be significant consequences to an organisation if records should be lost. Another area of risk relates to subject access requests. Many concerns about how subject access requests have been handled are brought to the ICO every year by members of the public. Problems can be due to staff not being fully aware of what a subject access request is and how to deal with one. For instance, staff may not know that a subject access request does not have to say explicitly that it is one, and a valid request could therefore be missed. We have received concerns where the subject access request was included within a complaint letter, the staff did not notice this, and the request was not passed on to the appropriate area. Subject access request responses are sometimes subject to redactions or exemptions. The work that is done while processing a response should be logged and reported. Otherwise, if there's a complaint about the response or the request is repeated, The organisation would not have any record about their previous response, so mistakes may be made or work repeated unnecessarily. A subject access request must be responded to promptly and in any event by 40 calendar days after it was submitted. A response to a subject access request that is later than this is a breach of the DPA.
Okay, I'll pick up a few more questions now, if I may. Very quick one, I think. Who actually is the data controller? Is it the organisation or is it the boss?
In this case, it would be the organisation that would act as the data controller.
Okay, thank you. As a healthcare provider, many of us have reviewed our organisation through completion of the NHS IG Information Governance Toolkit. Does this provide us a basis in preparing for the GDPR?
Absolutely. So we've touched previously on the fact that the Data Protection Act and the GDPR are very similar. So in completing the IG Toolkit, you will have a very strong basis for ensuring compliance with the GDPR going forward.
Okay, a fairly detailed one. How about sending documents by emails to clients that include their personal information? Do the documents need to be password protected?
They absolutely should be password protected where they contain personal information.
Okay. Is there special recommendations for clinical and health psychologists and therapists?
No specific recommendations. It's everyone that needs to comply and everyone that needs to handle personal information in the same way.
Okay, thanks very much. I'll hand back to Lauren now. Just want a bit of a plug for the ICO has a free helpline number, because unfortunately we're not going to get to everybody's questions, but just to give you that number that's available office hours Monday to Friday, and it's a free service, 0303 123 113 for any inquiries or questions that you've got. Thank you.
Okay, so before we conclude our session today, we hope we've highlighted some of the key risks that smaller organisations working in the health sector face. Some of you may already be aware of, some that may be new to you. But either way, we at the ICO would like to offer practical advice on how to address and manage these risks to ensure that you're data protection compliant and prepared for the introduction of the GDPR. So as I mentioned earlier, we're going to be holding a series of workshops which we'd like to invite you to apply to attend. The workshops are free of charge and are a unique opportunity to discuss the challenges you face and how to deal with them with expert advice from the ICO at hand to help and advise. The workshops will be held over 3 dates, the 11th of October at a venue in London, 7th of November at a venue in Birmingham, and 9th of November at a venue in Manchester. The main topics of the day will be information security, so thinking in light of the recent cyber attacks on the NHS, you can learn how to get the basics right. We'll cover GDPR and you can learn how to start preparing for the changes to the legislation. We'll touch on records management, discussing the life cycle of a record and how to ensure your organisation has the tools to get it right. And we'll cover subject access requests, how to avoid complaints and keep your service users happy. Further information about the times and venues and how to apply can be found on our website under About the ICO and News and Events. And we'll just move on to the last section, which shows you a little bit more information about the live chat, and you can find a link to our website there as well.
Okay, well, thanks again for joining us today. We'll close the webinar now, and the recording, as I've said a couple of times, the recording will be available on our website from tomorrow. News about future webinars go into our monthly e-newsletter, which has got over 120,000 subscribers. So if you're not signed up to that, then it might be a good idea if you did, to keep across when the webinars and any other updates that we make. We're also on Twitter at ICO News, and I'll plug the free helpline once again, 0303 123 113. So thank you again for your participation, and goodbye.